we will do a very short Q&A session with the rest of the speakers before we end our panel. I will start with a question for Philip, for Dr. Saranovic. Based on your presentation, I understand that the UK Supreme Court in the new Flamenco, although dealing with early redelivery of a vessel rather than the late delivery, ignored the fact that the owners managed to sell the vessels for a huge profit and therefore did not suffer any actual loss. In this case, could we say that this is consistent with the Court of Appeal's decision in the Skiros and the Agios Minas?
Thank you very, Mary, for such a great question. It is, I think, a matter of great debate whether the Supreme Court's decision in the new Flamenco is consistent or inconsistent with the Court of Appeal's decision now in the Skiros. Now, we do not know what the Court of Appeal thinks about this as presently constituted, because the case was not mentioned by the Court of Appeal at all. And similarly, the Commercial Court also ignored the new Flamenco. However, they are similar, and I think you're right to suggest that it can be consistent on the simple basis that in the new Flamenco, yes, there was early redelivery, but still it was a repudiatory breach of a contract, the charter party, and the owners of the vessel were awarded substantial damages for that repudiatory breach, despite the fact that they managed to sell the vessels when the market was at its peak. Subsequently, if the vessels had been delivered on time later, in that case, then they would have been redelivered at the time of the financial crisis. And therefore, they would have lost millions of US dollars that actually they profited from because of the breach. Now, the Supreme Court departed from the compensatory principle by saying we ignore the sale of the vessels and the fact that they made such a huge profit. So on this level, yes, absolutely, I think it helps the owners. And I think I would add also that the new Flamenco suggests also, in my view, that the purpose of damages in contract law, as far as English law at least is concerned, is not just about compensation, but it's also about, for example, making sure that there is a just outcome in circumstances that the party who is in breach does not get away with breach by not having to compensate the owners because of their own actions. On the other hand, I think equally we could distinguish the new Flamenco, and we could say in the Skiros and the Agios Minas, this current ongoing litigation, we are not really talking about taking into account the benefit under a separate contract, because the owners did not execute the MOAs in order to mitigate their losses. That was nothing to do with that. And therefore, as I said, from another perspective, the new Flamenco, you could say, does not actually really help the owners.
Mm-hmm. Thank you, Philip. That's very interesting. We see the well-established principles of compensation and mitigation of losses under UK contract law with regards to fundamental breaches being applied differently in each case. So very interesting to see where this will lead us. Thank you, Philip. Yeah, let's continue. Thank you, Philip. Let's continue now with Vasiliki. You mentioned Greece's hydrocarbon exploration south of Crete. How does the ICJ opinion change the legal risk profile of such legacy with regards to fossil fuel projects?
Thank you, Mary. In my view, when the ICJ states that granting new fossil fuel exploration licenses may constitute an internationally wrongful act, that is not an abstract language. It is a direct legal signal that such activities are increasingly incompatible with states' international obligations. For Greece, this may mean that the Crete exploration program, designed in a pre-Paris Agreement era, now sits in a, let's say, heightened liability environment. Investors may face challenges in establishing legitimate expectations, while the state may need to justify regulatory shifts as part of its due diligence obligations. And in short, the opinion transforms what was once a political debate into a specific legal risk calculus that both investors and governments must confront and take into account.
Mm-hmm. Thank you very much, Vasiliki. So commercial risk allocation and assessment when it comes to especially investors in this area does play an important role. Thank you very much. One final question for Bjorn. Bjorn, you mentioned very interestingly the need for good documentation, progress reports which track different issues such as notices, which will make arbitration faster and more cost efficient. How would this assist the expert in such kind of cases, and what is exactly the role of the expert in such disputes?
Thank you, Mary, for the question. In arbitration, there is seldom an expert appointed by the tribunal, but often the parties have their own experts. And the experts build their analysis on the data set they have been provided with by the parties, or respectively by the party that engaged the expert. And my proposal was to have one set of data that is agreed upon by the parties, which can then be provided to the experts. This has the benefit that both party-appointed experts, base their analysis on the same set of data, which would then lead to more conclusive results. Essentially leaving the tribunal with only having to decide the legal questions, the legal assessment based on the experts' findings. In particular, in offshore wind farm disputes, experts are very important, as we often deal with situations that concern project delays resulting from different factors like weather, non-availability of vessels, or defects of material like some blades that could not be installed properly and so on. And all of that need to be combined in one critical path analysis. And that is typically done by experts. The tribunal then has to see how that translates into either an extension of time that is to be given to the contractor or to additional remuneration for the additional work that was necessary to complete the project.
Mm-hmm. Thank you very much, Bjorn. So the same progress report will constitute the basis for the work of both party-appointed experts.
Yeah.
Great. Thank you very much. Thank you heartfully, the three of you, Bjorn, Vasiliki, Philip, for joining us and for making such very practical remarks, which do have a strong theoretical underpinning, but are also very much acquainted with in actual practice. Thank you very much for your contributions.
Thank you.
Thank you.